Hello friends, welcome to the second class of week 4. In today's class, we'll be talking about pre-litigation mediation. So in the previous class, we discussed about various types of mediation. Another type which we need to discuss in detail is pre-litigation mediation. So, the Honorable Mediation and Conciliation Committee, in its meeting held in October 2014, launched the concept of pre-litigation mediation on the parameters of Delhi High Court Mediation Center. So, the concept came into being when a meeting was held in the year of 2014 by the Honorable Mediation and Conciliation Committee. As per the concept of mediation, disputes which arise out of legal relationships, cases or matters of civil nature, money matters, contractual disputes, etc., may be received under pre-litigation prior to filing in the court of law. So, pre-litigation, as it suggests that before going to the court, a party can opt for the mediation process. So, such matters include matters of civil nature, money matters, contractual matters. So, before going to the court for the resolution of their dispute, they can go for the mediation process itself. Further, in the terms of Section 74 of the Arbitration and Conciliation Act 1996, settlement agreement has the same status and effect as if it is an arbitral award on agreed terms on the substance of the dispute rendered by an arbitral tribunal under Section 30. So, as per Section 74 of the Arbitration and Conciliation Act of 1996, the settlement agreement has the same status as an arbitral award has under Section 30. Under this concept, the applicant has to fill a pre-litigation mediation information form in which he or she has to submit his or her details, details of the second party, nature of the dispute, etc. So there is a pre-litigation form. That form has to be filled up by the party. That form will include information like the nature of the dispute, details of the party, details of the second party, etc. A format of the form will be shown to you in the coming slides. Along with this form, an undertaking has to be given with regard to the compliance of certain conditions of pre-litigation mediation. So, along with the pre-litigation form, the party needs to sign an undertaking as well. This undertaking is regarding the compliance to certain conditions of pre-litigation mediation. A format of the same will be shown to you in the coming slides. The proforma of the mediation information form and the conditions of pre-litigation mediation this has been gathered from the Mediation Information Center, Punjab and Haryana High Court, Chandigarh, is given in the next slides. So as you can see before yourself, there's this pre-litigation mediation information form. So it has the name of the applicant, address, contact number, email. Now, details of the person with whom pre-litigation mediation is sought for, the details of the second party, right? Then, nature or details of the dispute. Here, the nature of the dispute would be explained by the party. Then, as we discussed, along with the form, there has to be an undertaking. So, the undertaking is also provided. It says, I, the above mentioned applicant, do hereby solemnly affirm and declare as under. First, that the case or dispute mentioned above has arisen out of legal relationship. Second, I desire to get my dispute resolved through mediation in the Mediation and Conciliation Center, Punjab and Haryana High Court, Chandigarh, and would abide by the terms of the settlement to be reached between the parties. So, firstly, that party will have to say that the dispute has arisen out of a legal relationship and that they desire to get their dispute resolved by means of pre-litigation, and where the Mediation and Conciliation Center, Punjab and Haryana High Court. Since this form has been taken from that uh, Conciliation Center, Mediation Center, so it says Mediation and Conciliation Center, Punjab and Haryana High Court, and would abide to the terms of the settlement reached between the parties. I also undertake to abide by the terms and conditions of pre-litigation mediation annexed herewith. So the terms and conditions I'll show you in the next slide. So this is the pro forma of the pre-litigation form. Next, as per the terms and conditions for pre-litigation mediation, there's one annexure which states the conditions for pre-litigation mediation. First is that both the parties together or singly pay rupees 1000 in all as administrative charges of the mediation center. Second, the fee of the mediator, that is 10,000 in all, together or singly, shall be paid by the parties at the initial stage on appointment of mediator or depositing it with the mediation center. So the conditions, first condition was about the administrative charges. The parties both can together or singly can pay rupees 1000. Then the fee of the mediator has been talked about, that also can be paid together or singly. Then both, and when it has to be paid, that has also been specified, that it has to be paid at the initial stage of appointment of mediator. Both the parties together or singly shall pay rupees 500 per sitting for the use of mediation center. So per sitting for the use of the room of the mediation center, it charges rupees 500. The above amount shall be paid either in cash or through pay order or demand draft drawn in favor of the Mediation and Conciliation Center, Mediation and Conciliation Committee, I'm so sorry, Punjab and Haryana High Court, Chandigarh. So the amount, how the mode of payment would be, that has been told in this condition. Next is both the parties together or singly shall pay additional fee of the mediators depending upon the nature of the dispute, which would be decided by the Honorable Chairman. Next is that in terms of Section 74 of Arbitration and Conciliation Act 1996, settlement agreement would have the same status and effect as if it is an arbitral award or agreed on agreed terms on the substance of the dispute rendered by an arbitral tribunal under Section 30 of the Act. So next, the conditions talk about the additional fee that has to be paid. That would be depending on the nature of the dispute, and it would be decided by the chairman. And the condition of section 74, that is the nature of the settlement agreement, has been discussed by us earlier as well. So it has the same status of an arbitral award under section 30 of the Act. Which Act? The Arbitration and Conciliation Act of 1996. It would be treated as court litigation. It would not be treated as court litigation. I'm so sorry. It would not be treated as court litigation. It is a pre-litigation process and would not be treated as a court process of litigation. That the settlement reached between the parties would be in the shape of decree and can be enforced. So the settlement agreement would be in the shape of a decree and it can be enforced. Then there's one more affidavit which has to be given by the party, which says that I, so and so, daughter, wife, or son of so and so, a resident of so and so, do hereby solemnly affirm and declare as under. First, that I am a resident of the above said address. A copy of so and so is enclosed herewith as a proof of my residence. So, a copy of the address proof would be given. That no case has been filed by the undersigned in any court of law and no FIR has been registered. If FIR has been registered, then final report under section 173 of the CRPC, that is the Criminal Procedure Code, has not been submitted and trial in the concerned court is yet to commence. Then there's the date and the deponent will affix the signature. A verification would be given. Verify that the contents of the above affidavit are true and correct to my knowledge. No part of it is false, and noting material, uh, no material has been kept concealed therewith. So, the in the affidavit, the address proof would be given, and also it would be stated that there is no criminal charge that has been going on. There's no criminal case that has been going on in the case in the particular dispute. And if the FIR has been registered, firstly, there shouldn't be any FIR, but if an FIR has been registered, then the final report under section 173 has not been submitted and the case has not commenced yet. Also, a verification would be signed that the affidavit is true and correct to the knowledge of the deponent, and no false information has been given or nothing has been concealed. Now, pre-litigation mediation is indeed a consensual process where the plaintiff and the respondent attempt to settle their dispute with the help of an impartial mediator before filing a lawsuit or initiating the court proceedings. So, as we've already discussed, that it is a process which happens before the filing of the case or before the initiation of the court proceedings. It is a preferred method of dispute resolution because it allows the parties to choose their mediator, unlike in a lawsuit where a judge is appointed. Additionally, pre-litigation mediation aims to create a win-win situation by focusing on negotiation and understanding. So pre-litigation mediation is a preferred method because the parties have a choice on the mediator, that which person would they like to choose as the mediator, person or persons as the case may be, unlike in a lawsuit in which the judge determines the decision for the parties and the judge is not of the party's choice. Pre-litigation mediation, like other mediation process, the main aim is to arrive at a win-win situation for both the parties with the help of creating a mutual understanding. The scope of pre-litigation mediation is broad and can cover various types of cases, including domestic, commercial, consumer, property, and minor criminal disputes, among others. In family matters, family courts often encourage parties to consider mediation. So, there are various types of cases which can be referred to pre-litigation mediation. These cases include cases of domestic nature, commercial nature, consumer nature, property dispute, or even minor criminal disputes. Now, in case of family disputes, since the nature of the dispute is very private, it is very sensitive. So the pre-litigation mediation is preferred there, so that the parties can resolve their dispute by means of mediation before it gets ugly in the court of law. However, it's important to note that Indian laws do not mandate compulsory pre-mediation. So the Indian laws do not mandate pre-litigation mediation, but in the coming slides, I'll show you where it has been mandated. In the case of K. Srinivas Rao versus D. A. Deepa 2013, recognized This case recognized and acknowledged the concept of pre-litigation mediation specifically in matrimonial dispute. So as we've already discussed about family matters, matrimonial disputes are very sensitive, and if mediation can be helpful in resolving the dispute, then why not? The parties should go for mediation before approaching the court of law. In context of commercial disputes, the Commercial Courts Act 2015 provides a proper framework for the codification of pre-litigation mediation. An amendment in the year 2018 introduced Section 12A, which mandated pre-institution mediation in cases where urgent interim relief is not sought under the Act. So when we talk about commercial disputes, as per the amendment, uh, as per the amendment in 2018, wherein Section 12A was introduced, pre-institution mediation was made mandatory in cases where there is no urgent interim relief that is sought. The procedure for pre-institution mediation in commercial disputes is outlined in the Commercial Codes Pre-Institution Mediation and Settlement Rules 2018. So the procedure for pre-institution mediation has been given under the Commercial Codes Pre-Institution Mediation and Settlement Rules of 2018. These rules would be discussed in detail in week 7. We'll be talking about different legislations, wherein we'll be talking about the process, how mediation can be undertaken under different legislatures. That is all for today. Thank you, and I hope that you enjoyed the session.